a very, very narrow conspectus. Milord, we are persons, milord, who are of the same sex. We have, milord, according to us, the same rights under the Constitution as the heterosexual group of the society. Your lordships have held so. I don't need to reinvent the wheel. That we have exactly the same rights as our brethren of the heterosexual group of society, which is the majority. We are a minority. The only stumbling block on our equal rights, equal opportunities, equal dignity, equal fraternity, by virtue of 377, our actions were subject to criminality. Because it was criminality, my lord, it could not be equal in all measures of the heterosexual group. Criminality is now gone. The unnatural part or the order of nature under 377 is now effaced from our statute book. And therefore, our rights being equal in all forms, which are, my lord, reflected from Puttu Swami, Navtej, my lord, the judgments of this court on the right to marry a person of your own choice, Shafeen and all that, which I will show. If our rights are identical as held by the state, then we want to enjoy the full panoply of our rights under 14, 15, 19 and 21 to lead a dignified life, not mere existence like your lordship said in Francis Corali Bulin 40 years ago. To lead a life to our fullest extent with dignity, privacy in our home, and, my lord, without taint or stigma in public places. And therefore, we cherish and desire the same institution between two people as is available to the others, which is, my lord, the concept of marriage, the concept of family, because marriage and family is respected in our society. We don't, my lord, today, my lord, laws have now, my lord, progressed. In the Domestic Violence Act, even live-ins, my lord, are allowed. That is recognized by the court. Your lordship recognize it by even giving, my lord, property, money, inheritance, etc. So there is no reason why, once our rights are identical and same as held by your lordships, my lord. And that has been the development, my lord, in the US and other nations. I have made a one-page chart which I will show to your lordship. Therefore, my lord, we seek a declaration. Because we have to be concrete. What do we want from the court? We seek a declaration that we have a right to, my lord, get married. That right, my lord, will be recognized by the state and would be registrable under the Special Marriage Act and other acts. But as far as I am concerned, my lord, my brief is to say that we want a declaration that we have a right to marriage and that marriage will be recognized by the state by virtue of the imprimatur of this court. And once that happens, the society will recognize us. Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into
Now, Mr. Rocky, assuming that you seek a declaration from the court,
yes,
that queer people belonging to the queer community,
yes,
same-sex couples,
have a right to
have a right to marry, and therefore the state must recognize the
my
marriage
lord.
between these two. Now, what is the next step? Are you therefore saying that the Special Marriage Act already recognizes that right inherent in it?
Well,
A matter
my
of
lord,
an interpretative device or an
by an
interpretative
interpretive, my lord, I don't want it to be quashed or anything.
right.
By an interpretative device, in one line, if I was to say, the provisions, my lord, of the Special Marriage Act made in 1954. Today, my lord, we are now 70 years down. There is a lot of evolution. As I said, my lord, live-ins, etc. have now come in. I want to say, my lord, that your lordships will broadly read spouse in place of man and women or husband and wife. And that is it. And if I may show, my lord, a classic example. of the definition of marriage in Black's dictionary, which I have showed you, Lordship, in 1968, said, my lord, it's a union of a man and woman. But when the definition came in 2019, it says, my lord, a union of two persons. So concept of marriage has changed over last 100, 200 years. We had concepts of, my lord, group marriages. We had very different concepts. We had concepts of child marriage. We had concepts of, my lord, temporary marriages. We had concept that, my lord, prior to the Hindu Code Bill introduced by Pandit Nehru, my lord, in 1950, a person could marry any number of times. That, my lord, also changed. Hindu Code Bill, my lord, was not accepted. There were a lot of protests to this new avatar of the Hindu Marriage Act. It was not accepted. And Dr. Ambedkar had to resign. Then came the evolution of Hindu Marriage Act. Now in Hindu Marriage Act itself, my lord, in 2005, the rights which were restricted of women, starting from the Women's Right to Inheritance Property Act in 1937, all that has now changed, my lord. And full rights are available in 2005. So, my lord, Constitution is a living document. The preamble says, my lord, equality, fraternity. And I will read passages of, my lord, the Chief Justice, my lord, judgment, my lord, in Navtej, in Puttaswamy, in Shafin, in Deepika, and Justice Kaul, my lord, also referring to it. This is the thread. If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone if we are a part of all.
So really, your analysis is two-step. One, the declaration of marriage as a fundamental right
My lord.
as being implicit in the constitutional guarantees
My lord.
14, 19, and 21.
No, as interpreted by Lordships, my lord, in Puttaswamy, Navtej, basically.
And then step two, the second limb of your submission, that this also can find recognition by a reading, an appropriate reading of the Special Marriage Act.
My lord.
So you're not going into the broader issue of personal law and other things, we take it. Right?
No, my lord, I am not.
Right.
And I am not also touching any personal law of Muslims, etc., my lord. Somebody may raise an issue, I am not. Hindu Marriage Act, yes, but basic first will be Special Marriage Act. And your lordship knows, my lord, a legislative tool in the Indian legislative devices has always been that a definition clause always starts with, my lord, your lordships are aware, unless the context otherwise requires. That is the elasticity given to every legislation, more or less, in this country by Parliament, that you have to, my lord, adopt or adapt to 20, 30, 50, 70 years later. Can't keep changing the law, can't keep changing definitions. So you have, unless the context otherwise requires. So if the context requires that a man and a woman or a husband, wife to be treated as persons or spouses, your lordship will do it by an interpretative route, number one. Number two, this question, that whether, my lord, the court should wait for the legislature to act. Firstly, it arose, my lord, in Navtej. The court, my lord, entertained rather than waiting for the government to, my lord, remove it or not remove it. But there is, my lord, authority for the proposition in, my lord, Navtej, Chaira Banu, Puttaswamy, that the court need not wait for legislative, my lord, interference. And if it is brought to the court's notice that my fundamental right is being restricted, my lord, by the state or by this society because of its mindset, which has to now open up, the court's duty is to act. That is, my lord, clearly laid down. My lord, our lives are passing by. We are getting older. We also want to have the respectability of a marriage, respectability of a couple. What is the point of saying that only criminality in your bedroom is removed? But, my lord, when you go out, there is a passage of Justice Chandrachud, my lord, in one of those judgments, that what matters is what happens in a public space. What is the concrete position? If today, my lord, what is the position? All right, 377 is gone. But if these people, call them queer, call them strange, people call them all different names. If they were to go to different places, people look at them. Look, they are going this way, they are going that way, they are doing this, they are doing that. That, my lord, that is a restriction or an infringement of my right, which is Article 21, to, my lord, live with dignity, freedom, privacy, full expression of thought under 19(1)(a), no discrimination under 14, and, my lord, in 15, as the lordship knows, there will be no discrimination only on the ground of sex, creed, etc. And only on the ground of sex, Lord Lordship judgment, Justice Chandrachud, talking about Nargesh Mirza, that Air India case, and Milord, that Anuj Garg, that Milord, the Delhi hotels case where Milord, women could not Milord become employees. So your lordships have accepted Anuj Garg, which is an expensive definition of sex to mean sexual orientation. Sex does not mean, Milord, only male, female. And your lordships have, Milord, discounted the verdict in Nargesh, clearly. So Anuj Garg has been accepted by His Lordship Justice Chandrachud in that judgment, and also, Milord, in Nalsa, where we're dealing with transgenders, there are passage after passage that if you have to give them equality, that equality, Milord, also must reflect positively. So you have the negative part, don't discriminate. There is a positive part in 14 and 15, affirmative action also. Milord, sorry to say that Nalsa said that give them reservation. Years ago, nothing is done. Years ago. Your Lordship judgment, Milord, in Navtej, gave full publicity. Today I read in the Indian Express. Today, your Lordship judgment says give full publicity. People must know that it's not a criminal offense. Don't look at them with this stigma. Milord, years ago that judgment was delivered. Nothing done. And the three ministries today say, we have not done anything and we are not supposed to do anything. If this is the state of affairs of legislative interference or legislative response to judgments of this court, I have no choice but to knock at the doors of this court and say, Lord, I have a sense of deja vu. I was here. I opened the case on 377 years ago, before 5 judges, 5 years ago, in this court. This is how, my Lord, we reach step one. And there is a passage in Justice Chandrachud's verdict, which I will show, my Lord, that this was the first step. That is that sense. This was the first step. Remove that obstacle. Bring them up to the mark with the others. They will walk, my Lord, shoulder to shoulder. The Constitution said secular. What is secular? Regardless of caste, creed, color, sexual orientation, full expression. So we are a part of one homogeneous whole, but with dissimilarities of caste, creed, color, religion. But everybody is entitled in our secular polity, a pluralistic society. Justice Sabharwal, Milord, in Coelho, secularism is a part of basic structure. Equality is a part of basic structure. If they are a part of basic structure and a part of the triangle, Milord, I would say quadrangle, not triangle, 14, 15, 19 and 21. If they are a part of that which are inalienable, part of the basic structure, cannot be removed by anybody, cannot be tinkered by anybody, as understood by your lordships. I am not reinventing the wheel. Whatever I am saying, Lord, is actually a paraphrase of what I have read in the last couple of days from those judgments. And I will show you some passages. I am only going to put the pieces together, Lord. And I have, Lord, for a lordship's, Lord, convenience, Justice Bhatt might recall, Lord, in that reservation case, I had made a big chart to show you how the judgments went, Lord, in reservation. P3. Here I have made, Lord, your lordships found it, Lord, useful. Here I just hold on, Lord. I have made, Lord, a one-page chart. Starts, Lord, with 1860, the penal code. Your lordship, just have a quick glance. It will be easy. This will give your lordship, Lord, a very quick glance. Because I think only Justice Bhatt was there, Lord, in that case. The 5 judges here. Kindly, Lord, just see. Input my juniors, and not by me. I only dictated, Lord, the flow. So, yes, so today is the rainbow, Lord. This is the rainbow. Kindly see, Lord, Penal Code by Macaulay. In fact, Justice Chandrachud has used, Lord, the full name of Macaulay, which I didn't, which said Babington. Yes. Then, Lord, these were laws introduced in different colonies under the British Empire. 47 is our constitution. 67, Lord, was the Sexual Offences Act enacted by Parliament, which legalized homosexuality in 67. Now see, Lord, September 96, US is very, very, Lord, interesting. US federal government enacted DOMA, which stated that federal law shall not recognize the same-sex marriage. Because, my lord, pausing here for a minute, some states had started recognizing. So center came and said, we will not recognize because they have state and central lordship. So they formed, my lord, this DOMA that we want to keep away. Then, my lord, came Lawrence versus Texas. This was a case where there was a raid, my lord, in the house of Mr. Lawrence. And during the raid, he was found to be, my lord, committing an act which was held to be this unnatural act, and he was then charged. Object was raid, but they found him, my lord, in the bedroom, etc. So, in Lawrence, my lord, the Supreme Court upheld the right of Lawrence. It struck down, my lord, that Texas law, which was, my lord, akin to our 377. Then came Nas. Now see 2013. In Windsor, my lord, the Supreme Court struck down DOMA.